Welcome, everybody. We're starting promptly at 6 because we're being live streamed, and that means that we have to actually have something on the screen at 6 o'clock when we start. So we're starting right on time. So my name's John Lutz from the History Department at the University of Victoria, and it's my pleasure to welcome you all. I'd like to start by acknowledging that we're meeting on the traditional territory of the Songhees and Esquimalt people. And when I say that, I also say it as kind of a personal commitment and a commitment on the part of my history department and the University of Victoria to work towards that reconciliation and to tell truth, I guess, about the past. And luckily tonight our talk is actually going to do some of that, so it'll be part of that work. You're all very warmly welcomed, but I'd like to give a special welcome to the president of the university, Kevin Hall, who's sitting over here, and beside him is the chair of the history department, Jason Colby. So maybe you give them a welcome. This series is premised on the idea that there are many moments in history where a decision, a natural event perhaps, or a commencement of a process substantially changes the world in the decades and often the centuries that follow. And this week, we witnessed just such a moment when Russia invaded Ukraine, and we're all now witnesses to history, witnesses to tragedy. And we now live as people did in these kind of moments in the past, wondering what the future will bring. What does this mean for us? What does this mean for the world? And if you're like me, you're watching TV or you're watching the internet with a sense of rage, maybe despair, and probably a sense of helplessness. And at times like this, it takes me a while to figure out that we're actually not powerless. So I felt exactly this way 7 years ago when the Syrian Crisis broke out. You remember this, the tragedy of Syria and the war and the refugees and the drownings in the Mediterranean. And after feeling powerless for a while, I figured out with some colleagues in the history department that we could actually make a difference. We could do something about this. And so we our department sponsored a Syrian refugee family and brought them to Canada. And that was an amazing experience. It's an experience of expressing power in the face of this kind of overwhelming global tragedy. This family is now here. In fact, their son's at university. We've since sponsored a family from Eritrea, a family from Sudan, and we have 2 more families coming when the paperwork gets all done. I say this because, well, I say this not asking for applause, because what I'm going to do is say, we have an opportunity. You don't have to feel powerless now in the face of this Ukrainian tragedy. We have an opportunity. You have an opportunity. We all have an opportunity to do the same thing now. As you know, there are hundreds of thousands of refugees fleeing Ukraine. And on top of that, of course, there's I don't know how many tens of hundreds of thousands of refugees freeing Afghanistan and countries in Africa. The need is great, and all it takes actually is 5 people to form what they call a committee, and then you can work through the Intercultural Association of Greater Victoria and sponsor a family. So just if you're one of those people who is feeling like, what can I do? I can't do anything in the face of this tragedy, that's actually not true. If you want to make a big commitment, you can help sponsor a family. If you want to make a small commitment, normally at this time in Café Historique, if you're a regular, I pass around this magic bag and I ask for your toonies and $5 bills to help the history department pay for the rental space. Tonight, I'm going to donate the $200 to the rental space, and I'm going to ask you to put whatever you feel like in here, which will go to the Red Cross. And the Red Cross will double that, or the federal government will double that, and send that on to the Ukrainian relief effort. So instead of raising money for paying for Hermans tonight, we're raising money for the Ukrainian effort. And so I know, and probably if you're like me, you're saying, well, that's great, John, but I never carry cash these days with me, because I almost don't. And so that's fine too. If you want to, you can go home, you can click on the Red Cross donor link, and you can say to yourself, what feels comfortable for me to donate? And then you can add a little bit more onto that, because what's uncomfortable for us is nothing compared to what's uncomfortable for the people who are in Ukraine right now. So I'll pass this around in a minute. And I know you may be thinking, John, you're talking about Ukraine. What does this have to do with our talk tonight, 10 Days That Shook the World? Well, actually, there is a link, because our speaker today is going to be talking about an act of dispossession, an act of replacement, and an act of people being pushed out of their homes. So there is a link. I'd like to introduce our speaker now. Patrick Lozar got his PhD in 2019 from the University of Washington, And our department hired him just like that, even before he was done his PhD. And we're so lucky to have him. He did a degree at the University of Oregon, and then a master's degree at Montana State University. And in between that, he spent 2 years as a high school teacher, which you'll see when he presents. He's a very skilled presenter. Must come from those years as the high school teacher. His PhD focused on the Indigenous people on the upper, actually, well, on the Columbia Plateau, around where the Canada-US border comes together. And that's actually close to his home because he grew up on the Flathead Reserve in northwest Montana, where he's a member of the Confederated Salish and Kootenai tribes. His research focuses on Indigenous settler relations and dispossession in that borderland region. And today he's going to talk about a day that changed the world, June 15th, 1846. Please welcome Patrick Lozar.
Okay. How's that sound? All right? Okay. Thank you, John, for that introduction. It's so wonderful to be here. I've never been on a jazz stage before. My mom plays in a blues band with all older women. They're called the Hot Flash Blues. She's way cooler than I am, so I'm going to tell her about my experience on the stage tonight. I'm so glad that we can all be here together in this space and online, as well as we're still transitioning to this life of kind of hybrid, some COVID precautions, some precautions being lifted. And how we're all going to navigate that together. But we're gathered here at the Jazz Club because COVID restrictions have been lifted recently by the provincial government, which is a great sign for the pandemic. Since the COVID-19 pandemic hit North America and our region in 2020, government restrictions in Canada and the United States have caused a rethinking of social relations and infrastructure that we previously kind of took for granted. And one of those entities is the Canada-United States border. Many Canadians who frequently traveled between British Columbia and Washington State without a thought would begin to feel a sense of isolation and a curtailing of freedom to be able to travel through the border and back. That these travel restrictions prohibited for most entries by land or by water. And as someone with family down in the States, down in Montana, that feeling was strange. It was uncomfortable, and it was unwelcome. And it was difficult to not be able to go see family for those 2 years, year and a half or so. And knowing that the border was going to be closed with no end in sight, as far as we knew, back in those heady days of 2020, 2021. Now, the border has opened up since more and more, but we've also noticed lately, too, that there are those in the transportation industry, truckers, who have taken this border issue and made it in the news again, brought new attention to it, but for very different reasons than I'm going to be talking about tonight. So kind of interesting bringing back into the public eye as protesters plugged up ports of entry in Alberta and in Ontario in the past month or so. But I digress. Historians always want to bring the history into the news and vice versa to make sure it's relevant. Now, during the height of the pandemic in 2020 and 2021, international travel restrictions at the border were felt by Indigenous peoples and communities along the line whose connections across the 49th parallel go back generations. Now, the border created myriad complexities for Indigenous travelers, but interestingly, there also emerged some promises of movement rather than just containment. In 2020, 3 members of the Syrian Nation were granted a special travel exemption to go from their home in northeastern Washington State to Canada, specifically to Ottawa. Leading the group was Richard Lee Dissatel, who was a member of the Sinaiaks Nation and a member of the Colville Confederated Tribes in Washington and an American citizen. The Sinaiaks members, they were going to the Supreme Court of Canada in Ottawa to argue their case for the recognition of their hunting rights in their ancestral territories in the upper Columbia River country of BC. A decade before, Dissatel drove up to the West Kootenay and he shot an elk out of season, without a permit, and as a non-citizen. He immediately gave himself up to local law enforcement to be arrested, all in order to prompt a test case, a legal test case. And his position was that his people, the Sinaiaks, or the Arrow Lakes people, had hunted as well as fished and gathered wild roots and berries, and stayed in the region for seasonally for hundreds of years before any kind of arbitrarily drawn border divided their Aboriginal territories back in 1846. The Sinaiaks Nation lived in the north well before anything known as Canada ever existed. But members of their nation did drift southwards towards the Colville Reservation in north central Washington through the 19th and 20th century, based on push and pull factors of colonialism, violence, and displacement. The Canadian federal government thus declared their people extinct in Canada by the 1950s. But Dissatel went to Ottawa to say that they were anything but extinct. In fact, you can see in this image at the front steps of the court, Shelley Boyd, another Sinaiaks member, is holding a sign that says, "Older than the crown." And she's speaking to that deep ancestral heritage that the Sinaiaks have with this Aboriginal territory, that most of which is actually on the Canadian side of the border. Now, ultimately, in terms of legal position, Dissatel pointed to the Canadian Constitution's preservation of rights of, quote, Aboriginal peoples of Canada, unquote. The Supreme Court of Canada, considering the historical claims of the Sinaiaks Nation, sided with Dissatel and against the province of BC in determining that the Sinaiaks were Aboriginal people of Canada who retained their rights to hunt north of the border. If you've been in BC for the past decade, you've probably been following this story as it's gone through the provincial courts, appellate courts, and finally made it to the Supreme Court. Now, this 2021 decision would have profound implications for Indigenous cross-border rights in Canada. But the original 1846 decision that completed the Canada-United States border along the 49th parallel also changed everything. For Indigenous people in the North American West, June 15th, 1846 would be a day that shook the world. It was on that day in June that diplomats from Great Britain and the United States agreed to extend the boundary between their jurisdictional claims in the West along the 49th parallel. The line had originally been set at this line of latitude in 1818 from the Lake of the Woods in present-day southeastern Manitoba to the crest of the Rocky Mountains in BC, right about here. And in making these grand territorial decisions, these empires were operating according to the legal fiction of the doctrine of discovery. The discovery doctrine allowed empires to make claims to the North American continent and territory without consultation for the region's Indigenous occupants, as they were considered, as opposed to the Indigenous landowners. And extending the boundary line westward meant that, at least on paper, inhabitants of the region would be associated either with the United States in the south or British North America, or eventually the Dominion of Canada, in the north. And from 1846, these empires and nation-states would proceed with administering to this bifurcated region as if this were the case. Indigenous individuals, families, bands, communities would make no such immediate adaptations or changes to their patterns of seasonal mobility in their homelands. In the upper Columbia River country, the Salish-speaking Sinixt people and their Salish neighbors, the Sailks Okanagan, and the people of the Tanaha Nation, they continued to move along the north-south axis of the interior's mountain valleys in the decades after 1846. Hunting for larger game in the mountain parks of the above the Kootenai River, gathering berries along the creeks that flow into the Okanagan River, or gathering in large numbers to catch salmon during the massive fish runs at Kettle Falls, all remained vital economic, social, and cultural practices in the 19th century. This scene from Kettle Falls in present-day northeastern Washington state, right along the Columbia River there, would draw hundreds and hundreds of lodges on either side of the banks as communities would come to take part in these massive fish runs, and they fed the people, and people traded the salmon even further away from this site. Similar patterns of mobility persisted on the Pacific coast, the Salish Sea, the Strait of Juan de Fuca, as well as back across the Rocky Mountains in the northern Great Plains. Out here, in the inner waters, Coast Salish and northern communities continued to canoe to their fishing stations throughout the Gulf Islands and the San Juan Islands, Boundary Bay. Back on the prairies, those such as the Blackfoot and the Assiniboine, these peoples hunted bison, gathered plant foods, and traded across wide spaces between the Saskatchewan and the Yellowstone and Missouri rivers. And these dynamics persisted through traditional land-based patterns and seasonal rounds, but were also informed by new opportunities, such as the beaver fur trade, an industry that was introduced into the West from Europe and Eastern North America. Now, in terms of homelands and range, Indigenous nations recognized their neighbors' territories and communities and often entered into land and resource sharing agreements. As well, there was competition and encroachments and jostling for control of territorial boundaries, but it would be nothing like the rigid and abstract sense of territoriality exhibited by Western empires. For the British Empire, Canada, and the United States, the border between these claims represented paths of jurisdiction and incorporation, the line from which territories, provinces, and states could be carved out. The border also represented a point at which domestic laws and government administration began and ended. Controlling the mobility of Indigenous people with reserves and reservations, and eventually the pass system out on the prairies, this all coincided with the growing apparatus for monitoring traffic across the border. So this map is just an illustration of reserves and reservations in the interior, and the idea that these politically created spaces could act as containers of Indigenous mobility and identity, according to an Indian agent's jurisdiction. Now, controlling movements included the Northwest Mounted Police, the United States Army, and eventually customs and immigration agents and local law enforcement. And as settlers colonized the West and extended government powers, the technologies necessary for and the need for controlling Indigenous bodies actually proceeded along a more situational basis. Thus, Native nations and families encountered the border on a situational basis, both at the line itself and through domestic institutions far away from the boundary. And it's in this liminal space where peoples and governments have to figure out things like status and affiliation. And it all produces some complex, fascinating, and often tragic situations. Now, there's a trajectory or a narrative of the border hardening or closing that does develop over time, but I'm going to share some stories. A number of stories of Indigenous communities and individuals who held off or undermined the border's meaning, who adapted to its strict rules of affiliation, or who were captured in its many jurisdictional traps. And I think that stories are a good way to go. As the celebrated writer of Indigenous fiction, author Thomas King says, quote, "I get stopped every time I try to cross that border, but stories, they go wherever they please." So earlier I mentioned persistence, adaptation. And one story that exhibits these dynamics comes from the Okanagan and Similkameen valleys that are situated in south central BC and northern Washington state. And here, through the 20th century, families of the Syilx Okanagan Nation continued their modes of mobility along the well-established and culturally important paths of their homelands in the high country. For instance, Okanagan peoples migrated from the Okanagan and Skahad Lake areas down the Okanagan River to fish beyond Lake Osoyoos, and then traveled back upriver once the fish runs ceased later in the summer. Salish elders in the 20th century recalled Okanagan people participating in this migratory tradition, but without mentioning that There we go. When I did my job talk to apply for the job that I have, I was giving my talk, and there was a test of the Amber Alert alarm on everyone's cell phone in the middle of my talk. It was tough to recover from. We're all going to do it together. So this idea of traveling along these well-established paths to go fishing, it happened without mentioning that they had to cross an international border to go do this. Okanagan storyteller Harry Robinson told of the Okanagan people fishing at Osoyoos Lake and at Okanagan Falls, that at, quote, "that time, 1886, the people, Indians from Penticton and all the Okanagan Indians, there were some from Similkameen, and they all moved to where Oroville is now in the month of August. And they all got together in Oroville. That's where the salmon were coming up." You can actually see in this image where I'm talking about. It might not look as familiar because we're looking south, but here is where the town of Osoyoos, BC is. Here is, and this is all Lake Osoyoos. Here is where the pretty good-sized border crossing it is located. If you've ever been through it, it's a relatively major crossing with all the infrastructure that goes along with it. It's just not even present in this image. It's from 1905, but it speaks to the natural environment and the space that would have been unencumbered moving through by these Okanagan fishermen. Now, by the 1890s, the Okanagan Valley became increasingly settled with large agricultural operations in the form of hop farms. The farms needed pickers, and so the Syilx Okanagan folks, along with their Nez Perce neighbors from the Colville Indian Reservation in Washington state, migrated up to British Columbia to work in the fields picking hops for cash wages. They also happened to socialize with the with their northern Okanagan relatives and their friends during the hop picking season and afterwards. Now, by the turn of the century, the fruit orchard industry took off in Washington state. And with that, Okanagan families from BC would then travel south to pick apples for the season, again for cash. And same as earlier, these families, youth, adults, and some elders met together as well, and they used the picking season as a chance to visit their relatives and stay down south for several months. And this tradition persisted through the 1920s into the 1950s. And through these migrations, though they proceeded through an international boundary and into the jurisdiction of a foreign country, for the Okanagan people, they were moving through their Aboriginal territory to work and be around other Okanagan people. And thus their migrations de-emphasized the border and its meaning in a way that was not the case for Canadian or American travelers or governments, for whom the border did mean so much to identity, to authority, and the delineation of space. And sure, when they went south or when they went north, they did encounter the inspection station at Osoyoos, BC, or Oroville, Washington. And they traveled in cars and buses by then. But they did so along well-established routes that predated some imposed border. Now, in other cases, the border's marking of national jurisdiction could weave a confounding and illogical thicket of legal regimes, foreign status, citizenship due process, and diplomatic ambivalence. And these entanglements are evident in the curious case of Spope, a Gaina or blood Blackfoot man from Alberta. He was arrested, jailed, and tried in the 1880s. Now, Blackfoot peoples ranged a pretty large area of the northern plains in the 19th century. They hunted and gathered and raided from present-day Alberta down into present Montana. And the Siksika, the Kainai, the Pagan, these nations related together as the Blackfoot Confederacy. It's known as the Blackfoot in Canada or the Blackfeet in the United States. And these Blackfoot communities endured the wrenching challenges of colonialism and the colonization of their territory at the same time that they were seeing bison populations in the northern plains reducing significantly in the 1850s to the 1880s. At the same time, the US and Canadian governments began fortifying their domestic institutions to control and prevent Blackfoot peoples from crossing the border that ran through Blackfoot homelands. Because unsanctioned mobility made a mockery of the legitimacy of nation-state territoriality, and it rendered pretty difficult applying national status to a person's body. And though they were First Peoples, Aboriginal peoples, Blackfoot bands and individuals were subjects of the United States and of Canada. But even then, their legal standing was not necessarily a certainty. Add cross-border activities, legal standing, criminal justice issues into the mix, and that certainty is even less clear to either government. And this is not to state the obvious that for Blackfoot peoples, the Canadian and American legal systems were inaccessible, inconsistent, and inherently colonial. Now, enter Spope. 1879, Spope, who was a subject of Canada or a British Indian, allegedly murdered a white American man just across the borderline on Canadian soil. It was said that Spope then moved the body to the US side so as to avoid the Northwest Mounted Police taking him into custody. However, when state authorities in Montana heard about the discovery of a body, local law enforcement arrested Spope, who happened to still be on the US side in Montana territory. Now, this moving of peoples and bodies and all this, all these events and the evidence gathering for this case is happening on the northern plains, on the open plains where it's rivers and hills that mark the landscape, not fences or walls or even boundary cairns. There were very few boundary cairns. That's just like a pyramid that's made out of dirt that was often washed away or just torn down by indigenous peoples in the area. And so that's the space that we're talking about here. Spope was detained in a Montana jail until his trial with the U.S. District Court. So I'm going to pause for a second and say, let's think about this. Spope, who did not speak English, was a Canadian subject, but not a citizen, according to the Indian Act. In the U.S., he was a non-citizen foreign national and an alien Indian who, in this case, was charged with murdering an American citizen in Canada. Are you dizzy? Because I'm a little dizzy from trying to keep all that together. Right? It's that entanglement of different statuses and law that make this case kind of a head scratcher. Now, with the evidence compiled, such as it was, the colonial nature of the U.S. legal system, the federal court found Spope guilty, despite his national status, and the fact that the alleged crime happened on Canadian soil and in a foreign country. Now, he was going to be sent to execution. His death sentence was commuted, and he was going to spend 30 years in federal prison and eventually an asylum in Washington, D.C., before eventually being released in 1914. And upon his release, he returned to the Blackfeet Reservation in Montana, where he pretty soon after died the next year. But in sum, Spope's strange and tragic case was entangled with criminal justice, anti-indigenous racism, American imperialism, and illegal borderlands for indigenous peoples. And these colonial forces were thrust upon the same indigenous peoples who a generation earlier had moved about these same territories according to their own laws, traditions, and customs. Now, you might be familiar with the more captivating stories of Chief Joseph Nez Perce, Louis Brielle's Métis, Sitting Bull's Lakota, or Chief Little Bear's Cree from the 1870s and 1880s. And in these cases, indigenous mobility was monitored or prevented by force. The Northwest Mounted Police or the United States Army would intervene, but in these grand interventions, they were attention-grabbing, but it really didn't happen that often. More long-term, relentless, and effective modes of containing mobility involved compelling indigenous families and bands to relocate to the reserve or reservation to which they were assigned and to stay there. To administer to band or tribal communities, government agents needed their Indian wards to fit into specific categories, to be known and to be sorted. Being affiliated with, say, a reserve in British Columbia or a reservation in Montana meant officially and informally becoming a Canadian Indian or an American Indian. And this designation put boundaries around a Native nation's identity and would tether them to Canada or the United States. And with this political reorientation, any cross-border kind of consciousness or mobility would be discouraged, built into the system. And one particular indigenous community that had experienced the complexities and consequences of these narrow definitions of identity was the Ktunaxa Nation. For reference, the Kootenai or the Ktunaxa territory centered on the Kootenai River Valley in present southeastern BC, in northern Montana, and in northern Idaho. If you've ever been out to West or East Kootenai, you have to take the Crow's Nest Path, the most terrifying highway I have ever been on in the summer. I can't imagine what it's like in the wintertime. But the Ktunaxa people ranged over their territory in the 19th century, hunting, fishing, gathering from the land, and socializing with their extended family and kin all at the same time. And their relations brought them together. Families intermarried and stayed with each other for long or short periods of time. And from the 1880s to the 1910s, however, settlers began claiming lands in Ktunaxa territories from Columbia Lake down to Flathead Lake. So from way up here down to Flathead Lake, this is the region I'm talking. And here's the loop of the Kootenai River. Now, settler land use patterns and cattle grazing in particular, which requires a pretty good size of territory, this all made it difficult for Ktunaxa people to maintain their traditional land use practices that were so connected to their social and cultural worlds. And as settlement proceeded, local government officials and Indian agents gained the capacity to either coerce or incentivize Ktunaxa families to remove to the reserve or the reservation. And in the process, Ktunaxa patterns of mobility and social relations would grate against colonial notions of belonging and affiliation. At, for instance, the Tobacco Plains Reserve in BC or the Flathead Indian Reservation in Montana, belonging meant of being officially associated with or a member of a band or a tribe. And the Flathead Reservation is located about 125 kilometers south of the border. And at Flathead, where I'm from, I'm going to make a good example of this example because I've ties there. The membership in the Flathead Nation meant being enrolled. And by 1910, enrollment came with allotment. And with allotment, tribal members were assigned plots of reservation lands on which they were supposed to become farmers, and with allotment, as lands were distributed to tribal members, any surplus land would then be open to homesteaders for, it was kind of a nice scheme by the federal government to do double duty there. To determine who was a bona fide member of one of the three tribes comprising the Flathead Nation, the Ktunaxa, the Salish, and the Pend Oreille, or the Kalispel, government agents convened an enrollment council in which they made their final list, or the rolls. That's what they're called. The rolls were finalized in 1908. Ktunaxa families and individuals who were present and accounted for at these meetings were added to the rolls. However, over the next 15 years, dozens of Ktunaxa people would come forward to explain that they had not been present at the enrollment councils because they were either visiting family up in the north in Canada, or they had been away hunting and gathering, according to the people's well-known seasonal round. So tribal leadership at the Flathead Reservation here, along with the government Indian agent, and there were many who were assigned to Flathead over the years, they were tasked with adjudicating applications for enrollment from those not included in the original list. And so through the 1910s and into the 1920s, these councils received applications from Ktunaxa families, individuals, and parents of children who had familial ties to members at Flathead, but who had also lived in BC permanently or for long periods of time. Now, the flip side is kind of different because, according to the Department of Indian Affairs at this time in Canada, a band member who either lived outside of Canada for over 5 years, they would lose their band membership. Or if they married an American, whether as an Indigenous or non-Indigenous person in the United States, would lose their band membership. So there was a time limit according to Canadian policy. Not the same in this situation. Now, one case in particular illustrates the challenges facing those in these circumstances. In Louise Seymour's application, she reminded the council of the realities of Ktunaxa life before any hardened enrollment rules were ever instituted. Seymour was about 70 years old in 1921, and she explained there was never any issue to this union, and that at the time the treaty was made and concluded with the Confederated Tribes of the Flathead Nation in 1855, about 2/3 of the Kootenai tribe of Indians were roaming in British Columbia, where the Canadian government set aside a reservation for them, and this accounts for the Kootenai peoples traveling back and forth between here and Canada, unquote. Family members who lived at Flathead spoke on the behalf of those in Seymour's situation. Flathead chiefs and tribal leaders in council, they recognized and understood well the people's relationships, residences, movements, and in their understanding, familial and cultural ties took precedence over residence in a foreign country. However, the presiding U.S. government Indian agent at Flathead saw these applicants as strictly Canadian Indians or British subjects. And as such, they were foreigners with no legal status in the United States. The agent almost always voted against applicants who had Canadian ties. Chiefs and leaders in council, on the other hand, had little trouble acknowledging the applicants' cross-border relations and almost always voted to affirm their enrollment at Flathead. And in these cases, local Indigenous knowledge and relations could trump colonial constructions of belonging defined by national affiliation, foreignness, and international borders. As well, these enrollment cases and discussions demonstrate the persistence of Ktunaxa relations and kinship well into the first decades of the 20th century. Now, through the first half of the 20th century, more federal government resources were dedicated to regulating immigration and providing security at Canada's border and the United States border. Border checkpoints and ports of entry were more regularly monitored, particularly after World War I, and along main thoroughfares like the border at Douglas between Vancouver and Bellingham, Washington. And at the same time, immigration law took new precedence, and customs policy developed or matured in apace. And for our purposes, one of the main tensions in border enforcement policy was the local, as in the way local Indigenous territories and peoples were bifurcated by the borderline. So in Quebec, Ontario, New York State, the Haudenosaunee, or the Six Nations, have been dealing with the border running through their homelands since well before 1846. In fact, two of the Haudenosaunee communities' reservations straddle or are nearly adjacent to the border itself. So they're perhaps more acquainted than most with the border's uninvited presence in their homelands. Haudenosaunee, specifically Mohawk peoples, remained mobile in their ancestral territories into the 20th century, but for perhaps more unexpected reasons. Many Mohawk families had found themselves initiating a pattern of venturing south from Ganawage in Quebec down to New York State. They went down to New York City, in this city of tall buildings, where Mohawk men worked in the high steel building construction industry. They migrated often for this work, not just in New York City, but other sites like going to Montreal or going to Philadelphia, and working on projects that weren't just buildings, they were also building bridges as well, large steel projects. And with this increased traffic to the south, to work in high steel, Ganawage Mohawks began to resent the layers of bureaucracy and immigration paperwork required for entering and working in the United States. And this was at a moment in the U.S. when they passed a pretty comprehensive immigration law to restrict and curtail immigration from all over. And so the idea that this would impact the Mohawks was a great concern. So in 1925, a Mohawk couple from Quebec deliberately instigated a legal test case in Philadelphia. Paul Daibo and his wife Louise allowed themselves to be caught by U.S. immigration authorities for not having passports and for failing to comply with immigration policies related to work. Daibo did not obtain a work permit to work in the United States. The Immigration Office intended to deport Daibo back to Canada. The Immigration Commissioner said specifically that Daibo was a foreign national who was subject to any and all immigration rules that other Canadian nationals were subject to. Daibo, however, secured legal representation and took his case to court. Daibo's defense argued that he and all Indigenous Mohawk people retained the right of free passage or entry into the United States from Canada to work. And he based this assertion on a treaty between Great Britain and the United States from way back in the year 1794. And this relic, the Treaty of Amity, or the Jay Treaty is also known as, clarified a number of jurisdictional and territorial issues between Britain and the U.S. in the years soon after American independence. And mainly Britain was concerned in this case with in the 1790s with making sure to protect the fur trade that was made possible due to hunting, trading, trapping, and the mobility of their Indigenous trade partners in the East. So it was included in the Jay Treaty that the right of, quote, the Indians dwelling on either side of the boundary line freely to pass and repass by land or inland navigation into the respective territories and countries of the two parties was recognized. And based on this evidence, the U.S. Federal District Court agreed with Daibo's invocation of the Jay Treaty. The court decided in 1928 that the treaty was still valid and does apply to Daibo's case. Mohawk people would not be subject to the same policies or restrictions for entering into the United States from Canada. And this case would end up establishing a pretty major legal precedent. And while the ruling was important for Haudenosaunee peoples in the East, it would come to inform how other bifurcated Indigenous nations assert their border crossing rights in courts of law as well as in policymaking. And both the Daibo case and the Jay Treaty would be invoked in court decisions and in Indigenous political organizing for the rest of the 20th century up to today. And the ruling has been clarified in later court decisions that have been codified with legislation, with policy. The law says that a Canadian status Indian with 50% more Indian blood can enter and work in the United States without being subject to the same restrictions as non-Indigenous immigrants. However, Canada does not have a blanket reciprocal recognition of Indigenous free passage in terms of immigration. The way it's kind of been handled by Canadian immigration law, the CBSA, it's kind of more localized. If the border agent knows of a local Indigenous community that does span the border and really knows the individual crossing personally, then arrangements can be made on the local level. But there's nothing like like in the United States, in which even students who are status in Canada can go down to the United States for university. Canada's narrowed perspective on this all might change with the recent Dissatel case that's still in everyone's minds. Now, through all these developments in the latter 19th and through the 20th centuries, First Nations peoples and communities were freely crossing their bordered landscape when they could, or resisting, or laws that the border represented when necessary. But many were also adapting to or being subject to laws and policies that would and were intended to ground Indigenous mobility. The US and Canadian governments in general, and their policing power in particular, were growing in capacity by the first decades of the 20th century. Border patrolling institutions, state and provincial law enforcement, and Indian Affairs departments, both in the US and Canada, all discouraged unsanctioned border crossings or trans-border cultural connections. But we know that Indigenous people did not simply hive off their relationships, their sense of nationhood, or their ties to place. In 2010, representatives of the Colville Confederated Tribes and the bands of the Okanagan Nation Alliance in BC came together to affirm their cultural and political relationship and to pledge support for one another in what has been called the Unity Declaration. The Colville Tribal Chair acknowledged the border's presence in their territory, asserting that, quote, "Despite this impediment to our unity, we have persevered as the unbroken Sailks Okanagan Nation." And that's what they're kind of celebrating or cheering here and recognizing the Unity Declaration in Okanagan territory. In the past 30 years, cross-border mobilizing has informed Indigenous cultural and political resurgence movements. Native nations have coordinated with community members from both sides of the line to bring together cultural knowledge and language to revitalize these crucial components of Indigenous identity. Traditional ecological knowledge keepers, elders, community members have held conferences and language workshops and have organized field trips to learn with each other and learn from the land. And some of these events are, experiential embodiments of cultural resurgence. Consider the canoe journeys. Canoe journey events that have been going on since the 1980s. On the coast out here, seafaring communities canoe up and down the coast on their way to that year's host in their community. While the journeys are coordinated with Coast Guard or with Border Patrol, they're representative of the Indigenous gatherings and the canoe travel traditions that proceeded across the Salish Sea well before any border was set upon the waters. Other actions have been more political in nature. Members of many communities have held border rallies that remind the settler state that this line is a fictional entity, but that they also retain their ability to pass and repass the 49th parallel. Specifically, they've been critical of things like new passport rules or having to pay customs duties when they get to the border. And many of these concerns really grew significantly after 9/11 and the increased border policing and passport control initiatives. In fact, this meeting with the Okanagan Nation, they were responding to the expectation of the rule that they would have to show a passport rather than just a status card or a tribal ID to cross the border. Border nations also engage in political organizing that does not necessarily get the same kind of headlines as Idle No More movements at the borderline itself, for instance. In terms of policy, tribal representatives have established intertribal organizations to inform and shape how governments implement immigration law and how Border Patrol agencies understand the unique rights of Indigenous travelers. There's a lot of turnover with CBSA at many different, mostly rural border crossings in which they might just work there for a summer and have very little training. And they sure as hell don't know about the Jay Treaty of 1794. So trying to inform and educate personnel at the border is one of these initiatives. So the Akwesasne Mohawk back east and the Kootenai Tribe of Idaho have formed the Northern Tribal Border Alliance to lobby, inform, and educate U.S. and Canadian policymakers in order to sustain more productive relationships between these various parties. And we've also seen resiliency of border nations through the COVID pandemic. When COVID became well entrenched in 2020, First Nations, Native Americans, were some of the most vulnerable populations in North America. And when the border closed that year, Indigenous community interactions were either truncated or just ceased altogether. No traveling down for cultural celebrations, or even back home at Flathead, there was some deaths, and they couldn't cross the border to go down for funerals, and that was really difficult for cross-border community members. However, when the introduction of the COVID vaccine spurred border nations into launching vaccine clinics, the U.S. Had distributed the vaccine to Native American tribes before Canada could ramp up its distribution efforts in earnest. And so in 2021, the Blackfeet Nation of Montana set up a border clinic to provide their excess vaccine doses to Blackfoot folks from Alberta. And then the Kootenai Tribe of Idaho did the same for the Lower Kootenai Band from Creston, BC, soon after. The Kootenai Tribe of Idaho did this on a specific day, on Indigenous Peoples Day, in which every year for the past several years, they have conducted a kind of a border crossing event in which they, as a group, walk across the border in kind of Port Hill, Idaho, Rooseville, Montana area, to remind the government that this is a fictional entity. But when those doses of the vaccine were shared, they opened it up to non-Indigenous residents of Alberta and BC once the Blackfoot and Kootenai or Ktunaxa members received their shot. And these clinics, they really represent the possibilities for mobilizing enduring community ties in spite of a pandemic. Next, to conclude, I want to make some connections between responsibility and international borders in the context of Canada's commitment to reconciliation and First Nations. 3 years ago, 2019, British Columbia chose to adopt the United Nations Declaration on the Rights of Indigenous People. This document, shortened as UNDRIP, which is a pretty unflattering acronym, calls upon member states of the UN to recognize the distinct rights of Indigenous people the world over. And it acts as a reference point for governments working with Indigenous nations. And this document provides a number of decrees for states to incorporate. But for our purposes, Section 36 of UNDRIP holds that, quote, Indigenous peoples, in particular those divided by international borders, have the right to maintain and develop contacts, relations, and cooperation, including activities for spiritual, cultural, political, economic, and social purposes with their own members across borders. So clearly, First Nations or communities are doing this work despite all the challenges that they face and that they have faced. So it's up to the Canadian and the United States governments, according to UNDRIP, to support and facilitate this declaration. And in an era of reconciliation in Canada, we have to ask ourselves, how are we continuing to make this provincial, national, and international call to action a reality in our society and our government today? So, thank you.
Thank you so much, Patrick. I'm sure there are questions for you, and we have time for questions. So, I don't know, Tom, can you turn up the lights a little bit? Is that possible? The house lights? All right, thank you.
You are kidding, these lights are quite bright.
They are bright, yeah. I'll start. I see one in the back, and there's one in the front here too. Yeah. Go ahead.
Right.
At the time of the negotiations of the Oregon Treaty, the original treaty, was there any consciousness at all of any Aboriginal rights or any concern about that at all? And second question is this, as a matter of interest, was the Selective Services Act in the U.S., the Draft Act, did that apply to Native people as well, or to Indian people as well, as American citizens, as ordinary American citizens?
Yeah. Yes. The question was about the Oregon Treaty and if the document or the discussions mentioned Indigenous people at all. And the short answer is no. There was a really keen interest in the negotiations in the document for protecting the Hudson's Bay Company's properties in the what was called the Oregon Country out here. That's what the participants and those interested parties were really concerned about. So whether that extends to the perpetuation of the fur trade out here and the Hudson's Bay Company's partners with the Indigenous fur traders, that was probably the extent of it. But in terms of legal recognition, no, they weren't brought into the discussion. They certainly weren't present at any of the negotiations at the time. And the second question was about selective service, which is the draft in the United States, and whether Native American men would be subject to selective service. That's certainly the case after Native American men become citizens. And there's a blanket citizenship law in 1924 that says just all of a sudden any Native American person is a citizen of the United States. Poof, like with the scratch of a pen. And thus they would be subject to selective service, which is signing up for the draft when you turn 18. I'm subject to that. So that's why I came up to Canada, to get out of the United States, not have to. No, come on. So that is the case. Before 1924, that was not necessarily the case. So.
I think, I'm not mistaken, it's Councillor Van Issett in the back there.
Patrick, thank you for an excellent presentation, and thanks to the department for hosting the event. I think your comments around cross-border migration are really compelling. The familial ties, the labor migration, and I think on the coast here we've seen that with the Wasanich communities on the peninsula here, crossing over to the Puget Sound area for seasonal work, and even up north with the Haida now divided by the international boundary with the Haida community of Heidelberg on the American side, and then the Masset and Skidegate communities on the Canadian side. Your comments around enrollment, I think, are really compelling, and when I was reviewing some of the recent treaties, it really stuck on me that Indigenous people are forced to decide which part of their birthright will they draw on. And the equivalent for settler people like many in this room is you'd have to pick to either access your mother's, either an inheritance on your mother's side or on your father's, and that you couldn't have both. And that's essentially the position that Indigenous people, it sounds like on both sides of the border, have been placed in. So I guess my question would be, what alternatives to singular enrollment in a band were either contemplated at the time, or do you think would be feasible now in the 21st century to allow for Indigenous people to be affiliated in a formal way with their diverse and multiple lineages as settler people are able to?
Did you hear that? Okay, it's a great question. Thank you so much. And it speaks to the the challenges of Indigenous understandings of kinship and nationhood, and what the state says is a category that is accepted, right? And so he was asking about, well, does an individual with perhaps a mother from one band and a father from another have to pick, or is there other options? And that's some of the challenges that go along with these pretty narrow definitions of membership. Because if someone is officially enrolled in one community, do they lose their membership in another community? And at these moments, certainly at the turn of the century, there are those who were enrolled in both places until someone found out, right? The Indian agents always complained about families going up to BC, collecting whatever annuities or something, and then coming back down and staying in the United States, or vice versa. And it just didn't compute. You can't do that. That doesn't work with our system, right? And so, exactly. Yeah. Well, I mean, that's just an extension of these migrations and the accessing what was available, And so the challenge of having to decide one or the other is the problem. But it's built into the system of things like blood quantum rules that say if you are of one group and your parents are from different groups, that dilutes your Indian blood to the point when your kids and your kids' kids won't be considered status anymore, or a potential tribal member anymore. And so it's just built into the colonial system. Now, there are those, certainly in the United States, as tribes have been able to take control over their membership rules and determine their categories of enrollment based on documentation or kinship or people vouching for you and going through the process. That is less rigid for some communities and hasn't actually changed much in the past 100 years for other communities. So it's pretty diverse, but yeah, it's all built into that colonial system. Thank you for the question.
So just a comment first. The April 15th, 1846 date, for years bugged me when I worked with First Nations, because it was an Inherent Conservation Act, and stated that anything that was in the ground from before that date belonged to the crown and nobody but the crown. They thankfully changed that. But what's still going on is the modern day treaty process. They are insisting that you can't have ties across the border. Your members that aren't Canadian citizens cannot join your treaty. As in Tsawwassen, all their members who would be in Washington State cannot be part of it. And they have to choose to be, and people enrolled in Tsawwassen have to agree that they're not part of any other First Nation in Canada. And so the treaty very specifically says you can't get entry into Canada or Canadian citizenship or any rights in Canada because you're not allowed to be enrolled. And that's what we're doing today. So, commentary on that?
Yeah, no, thank you. It speaks to those rigid definitions, of membership that show the extension of the Indian Act and how much of a role it plays into Indigenous communities' lives and individuals' lives today, and how some of these rules are either kind of nonsensical, or they're so rigidly nationalistic that they couldn't possibly comprehend, a blood tie or a family member being from one side or the other, or being born in, say, Washington and living their whole lives in BC and still not being considered a member, or vice versa. Yeah.
One of the First Nations I worked for in the treaty process really wanted to have control over membership. They wanted to define themselves not by blood quanta, not by anything, but by basically having their own system of accepting people. Didn't matter who they were, and that's what the community and federal government quite simply said no.
future. So if they're not status Indians and don't belong to you, we have no interest.
Right. Yeah. And that will then potentially reduce the amount of status Indians in the schema, the blood quantum schema. Absolutely. An interesting kind of comparison, my dad was on the tribal council at Flathead for 10 years, and they'd go up to Cranbrook to the big gathering of Tanaha and would talk about these kinds of things. And one thing that they kind of realized in terms of either's relationship with either federal government, it was kind of like in the United States, the federal government says, here's what you can't do. Everything else you can. In Canada, it was, here's what you can do. Everything else you cannot. And so they immediately talked about, casinos. Like, why can't we run casinos? Well, it's not that's not going to work according to that Canadian arrangement, right? And so that shows some of the differences of experiences in a political sense between the two on a large scale. Thank you for your comments.
Christine, right there in front row.
Thank you for the excellent talk. I'm going to preface my question by saying my office is beside Patrick, so I could ask him this tomorrow, but I'd like to do this in front of the whole room.
It's going to be a softball, right?
So right when you began speaking, I immediately thought of the Jay Treaty. I'm somebody who comes from a nation on the East Coast. This has very much defined my life and the experiences of my family members. And I, as a young person, traveled over the border, and my father, not holding a driver's license, would travel on his status card. And I remember being pulled out, and my father being asked about blood quantum and those sorts of things. So that's very familiar to me. But what my question is, and I've been on the West Coast now for almost 15 years, and it isn't clear to me, I'm still not sure how the Jay Treaty, something that was ratified in 1794, in this eastern region and is applicable in those political and cultural contexts. You talk about how it's taken shape in legislation and policy with the establishment or the creation of the settler colonial states. How is the Jay Treaty recognized westward, particularly in the western regions, and the legal recognition, and I guess the legal recognition, as well as how it's understood in communities such as your community and the assertion of that legal right under an 18th century treaty?
Yeah. Thank you, Christine, for that question. Basically, the question is about this thing that was mostly an Eastern phenomenon. How is that being used or invoked in a Western North American space? And it's really not until, like I mentioned, the Daibo case, the Mohawk case, that gets people talking about this Jay Treaty as a point of reference, as a thing that could be pointed to for legitimacy for border crossings. And that happens in the courts. And eventually it happens in the in policy circles. I think it's 1956, there was a Canadian court ruling that said we don't recognize the Jay Treaty as still being legitimate because it was abrogated by the Treaty of Ghent in 1814. So it's pretty well established that it's not the case in Canada in the same way it is in the United States. And so as different communities are trying to push on laws related to bringing stuff into the United States from Canada or vice versa, like goods that they don't want to get taxed, then they invoke the Jay Treaty to try to seek resolution in that. And so as cases come up, there's several mid to low profile cases throughout the 20th century by different communities that either try to invoke the Jay Treaty or are successful in doing so. One in the early 2000s by a Senex member, not Rick Dissetel, a guy named Robert Watt. They tried to invoke the Jay Treaty in way out here in BC and Washington, unsuccessfully in this case. And so it's as Indian policy and law becomes, goes through the universities and through the legal circles around the country, around North America, that it begins to come into discussions as possibilities for recourse. So, yeah, it's a series of kind of incremental steps that different communities try to draw upon. Yeah. Thank you for the question.
Can I just say thank you? I loved all the historic photos and all the maps and everything, and I hope you give this presentation often to different audiences. It's very informative. Thank you.
Thank you.
No questions.
Thank
just
you.
all.
Thank you. Thank you.
Many people in this room will know that we are treaty people here in Victoria. We have our governments, colonial governments, signed treaties with the local First Nations. At least there are multiple interpretations of those treaties, but those treaties contain rights that were granted to the local peoples which haven't been honored, like rights to fish formally, for example, the right to hunt over unoccupied territories. So we have local treaties right around here, one of the few places in British Columbia that's treated. Just across the border, and those were signed in 1850, 1852. And then in 1854, just across the border, the Washington treaties were signed, right? So the Stevens treaties, we call them. So this is a question now coming towards you. So I think, if I'm not mistaken, in the Stevens treaties, there's prohibition for Indigenous people who've signed the treaties to come up to Victoria and shop at the Hudson's Bay Company. So you're not aware of this prohibition, the Hudson's Bay Company prohibition, no? So Governor Stevens was worried at the time that all of the Victoria was the metropolis at the time in the 1850s, and so all the Indigenous people from Nia Bay and from Port Gamble and even Seattle and stuff would come to Victoria, to the Bay, the Hudson's Bay Company, to do their trading. So I'm pretty sure I'm right about this. There's a provision in the Stevens treaties which says you can't go to the Canadian territory and trade. So it actually is a reverse of the Stevens treaties, of the Jay Treaty. It's a reverse of the Jay Treaty.
Interesting.
So I have another question for our speaker. So when land title questions go to court in Canada, when First Nations take the government to court and say, we have Indigenous rights and these are our rights, the government says, no, you don't, because Canada has sovereignty. And they say, well, Indigenous people say then, well, how does Canada have sovereignty? And I think that almost all the court decisions go back to the Oregon Treaty and say, at this moment, Canada received undivided sovereignty. In other words, weren't sharing it with the United States, and that is the magic moment where settlers owned this territory. And then when the Indigenous people ask, well, then how did you get that right? There's no answer there at the end of that, except for the answer that Patrick gave us tonight, which was people have moved into our territory and taken that away. Any more questions for Patrick before I say a few thank yous? One more from Dr. Colby.
Super fast one. It strikes me as you were walking through this how, in so many ways, Canada is actually more restrictive in sort of interpretation of this freedom to cross the border. But it's quite the contrary with citizenship, right? With sort of settler dual citizenship, which Canada is very generous with, and the United States is quite exclusionary. Right? I mean, if you swear citizenship to the U.S., you have to forswear citizenship to all other nations, right? It's quite an exclusive citizenship, whereas Canada actually is fine with dual citizenship, except clearly for Indigenous people, right? I mean, I say this as somebody who's benefited from dual citizenship. The U.S. sort of ignores it. Canada's quite lovely for me with it, but I found myself listening to this thinking, wow, Canada's been much more generous to me, considering me a dual citizen, than to its own Indigenous people.
Yeah, I'm certainly less familiar with the particularities of dual citizenship, but again, it gets even murkier with those band members in Canada who do have or claim to have dual citizenship in the United States. Where does the rubber meet the road? Is it when you're paying taxes? Is it when you're driving up to the border agent who's going to look through your car? That's when those kinds of things really come into your life and come into play. But yeah, that's an interesting parallel. Thank you, Jason.
So I want to say a few thank yous, but before I even do that, I want to let you know that the next Café Historique, the next day that changed the world, will be coming up as usual on the first Tuesday of the month, which is April 5th. And at that time, our colleague Andrew Winder is going to speak about the 1st of February 1979. And I know you're all saying, of course, the 1st of February 1979, the day Khomeini returned to Iran. And you were right about that. That is the day that he's going to speak about in a month's time. I'd like you to join me in thanking the staff of Hermann. So we've got Rosanna walking around, Megan behind the bar, Tom on the lights, and oh geez, at the door. Oh, I'm sorry, forgotten again. So thanks, folks. They do a great job in making sure we all get watered and fed and enjoy our talks. I also want to thank all of you who put some money in that little bag I passed around, and encourage you to remember that, you know, if you can find the capacity in your wallet and your budget when you go home to make a donation to the Red Cross, which will be doubled by the Canadian government and will help people who are in dire need in Ukraine. So thank you for those who have made donations and those who will make donations. A round of applause for you too. So thank you. And that leaves for me to thank our speaker, who has given us a story about our own history of dislocation and dispossession and regulation. And it's been a great pleasure to hear and learn from my colleague, Dr. Patrick Lozar. Please join me with a round of applause. I look forward to seeing you all in a month's time. Thank you.